So we're delighted to be exploring whether the Equality Act of 2010 should be revisited, even scrapped. So this is the Flip Side podcast. And we are joined today by two excellent contributors from very different perspectives on this subject. I will give details of their bios in the description below, but we have Joanna Williams and Audrey Ludwig. So we're going to dive straight into it. As always, each speaker will give a 2-minute introduction. Then they will have the opportunity to ask each other questions to clarify any points of disagreement. And then I'll ask some questions at the end, but I may interject throughout the discussion. So we will start with yourself, Audrey. May we just have some opening thoughts for you?
Thank you for inviting me. I'm a recently retired legal aid discrimination lawyer who worked in a law centre in East Anglia. From about 2006, I helped thousands of low-income people alleging unlawful discrimination and harassment, covering all the different protected characteristics. My clients were subject to horrendous, unjustified and prejudicial treatments by employers, service providers, public bodies, transport providers, etc. About half my clients were disabled. The effect of the unlawful discrimination was detrimental to their health, to their employment prospects and financially. Their only legal recourse was Equality Act, the Equality Law, and its predecessor laws. The strength of the Equality Act is it applies universally, as everyone is at risk of potential possible unlawful discrimination and harassment. Everyone has the right to challenge it in law. Over the last few years, this subject has been hijacked by activists and misinformation is rife. But the essence of the actual law is fine, is moderate, and done properly, it works well. There is always scope for improvement, but that process of changing law is very difficult and complex and should be done carefully, and particularly listening to practitioners on the ground like me. The report don't divide us. The methodology they've used is very problematic because it only looks at cases which reach final hearing, not those issued, and certainly not those successfully settled. In my experience, the vast majority of good cases are settled and don't go to final hearing. So essentially, they were only looking at more difficult, complex cases where people were quite often unrepresented. The report is also very one-sided. They've not explored how it prevents a race to the bottom by rogue employers, etc. A society where prejudice, inaccessibility and positive discrimination towards the favoured groups of the moment is lawful is not one that I want to live in. Even the costs of excluding people based on unjustifiable grounds from jobs, services, etc. are not quantified. We're not going to necessarily save money by getting rid of the Equality Act. So my view on the whole is that the law is okay. Where it falls down is around the guidance and the training needs improving.
Great, thank you for that comprehensive opener, Audrey. Joanna, could we just have your 2-minute introduction?
Yeah, thank you, and thank you for inviting me as well. So I've got to stress at the beginning that I'm not a lawyer. I have no legal in-depth knowledge of the Equality Act in any way, shape or form. I'm an academic, author and commentator by professional background. And actually I was working in a university at the University of Kent in the education faculty when the Equality Act was first introduced into law. And at that point, we were told to think very carefully about our teaching, that it was very important to make our teaching inclusive, which had been a long-standing feature of our teaching and something that's very hard to disagree with. But the change that we were told to think about in relation to the Equality Act was, rather than waiting until students came to us to say, I perhaps have dyslexia, or I would need my handouts, for example, to be photocopied onto a different coloured piece of paper, that we had to be proactive and preempt possible changes to teaching. And what that effectively meant was that if you were teaching a lecture hall of a lecture of 100 students, you would potentially have to take any number of disabilities into account in advance of your teaching. So think about every different possible coloured paper for handouts, think about every different kind of font size. And whilst I think it's very important, obviously, to make your teaching accessible, to do this became actually a completely impossible task, because often the demands that students were making would be completely contradictory, or the demands that we were being asked to preempt, rather, would be completely contradictory. So one person would prefer white print on black background, another would prefer black print on white background. You clearly cannot do both. And sorry, that's just an anecdote, my own personal experience. I have two main points I'd like to make at the beginning, I guess, in relation to the Equality Act and my criticisms, where I'm coming from. One is that it represents, it seems to me, a shift from formal to substantive equality, or from equality of opportunity to equality of outcome, or we might say from equality to equity. So what this means is, rather than the law saying that everybody should be equal under the law should treat everybody the same, it actually enshrines treating people differently within the law. So this enshrines difference based on these 9 groups with protected characteristics. It enshrines identity-based equality in the law, and even though it's called the Equality Act, it seems to me it actually enshrines inequality in the law, and that for me runs the risk of pitching people against each other based on these identity groups. A second quick point I'd make is that the public sector equality duty, again, which asks people to preempt discrimination, as I was saying in relation to my own teaching, my own experience, really I worry creates an industry that overinterprets the law. I think we've seen this most clearly with Stonewall, where the phrase that there's law and there's Stonewall law has become quite commonplace, and we can see that a lot of different universities and organisations around the country are now falling foul of having followed Stonewall law in relation to gender and gender identity, on the basis that they need to preempt discrimination, and are now coming a cropper because of that. I think it puts diversity before delivery, and it denies the kind of common sense, basic things that everybody has in common, that everybody wants. It stokes grievances between different identity groups, and it acts as a barrier, I think, now to solidarity between different groups of people.
That's great, thank you. So just before we move on to the quick fire round, just to summarise your thoughts, of course, add or correct anything you feel you need to. So from Audrey's side, do you believe that the strength of the Equality Act is that it applies universally? The essence of the law is fine, and when done properly, it works well. Any improvements should be done carefully by sort of consulting the practitioners. The report you don't believe is divisive, and you feel that there's kind of a narrow view sometimes when it comes to the Equality Act, in terms of some people only making it about race, but there are other parts of the law which you felt that the report, which we should clarify is a recent report by Don't Divide Us, correct? Yeah. Which you feel some points were problematic in its methodology, and it was quite one-sided.
Yeah, I would just say that the report which sparked this conversation, Don't Divide Us, essentially was advocating for either whole-scale changes or abolition of the Equality Act, but it was only looking at race. And I think a fundamental criticism of it is, if you're going to change something, then in practice you have to be completely clear about the totality of the legislation, and to focus in only on some perceived concerns about race when you're dealing with when you're dealing with 9 protected characteristics, I think is very problematic.
Yeah, I think that's a valid point. I think at the start they did clarify or mention that they did specifically look at race. They did advocate for sort of the re-looking at the Equality Act, but they did mention that they would need to be a more deeper look into the other parts of the law. So I understand where you're coming from, but they did make that mention at the top of the report as well. So Joanna, from your point of view, you believe that this Equality Act has affected areas like academia, which you are in, and you feel that there is a shift that emanated from this law, which went from equality of opportunity to equality of outcomes, and it enshrined differences based on these 9 protected characteristics that are mentioned in the law. And you believe that it kind of puts groups and people against each other. The Public Sector Equality Initiative asks people to preempt discrimination, which creates that industry that overreacts or perhaps overinterprets the law, putting diversity before delivery, which takes away the commonality and common humanity that binds us all together.
Yeah, that's right. I mean, I guess the only thing I'd add to that is that I think equality before the law is an incredibly important principle. And it was also a very hard-won principle. If you look at the civil rights era, movements that we've had in this country towards feminism, towards challenging racism. I mean, even go back to the suffragettes and women's kind of fight for the vote. The fight for equality before the law is a really, really important struggle. And I think that's why we lose that at our peril. And I think the Equality Act takes us away from equality before the law.
Okay. So on that note, Audrey, would you like to ask Joanna any questions? It can be in relation to her opening statements, or it can be anything that you feel you want to clarify from that side of the argument.
Yes, I do have a question, a couple of questions actually for Joanna. Your concern is that the law, and I stress I'm talking about the Act rather than the application of the Act, because I think we both share concerns about the way the Act is applied, but the Act itself prioritises equality of outcome as opposed to equality of opportunity. Would you accept that your view is very much coloured by the way it's been applied rather than the pure wording of the Act? Because my view is very different. It's completely the contrary, that essentially it's about equality of opportunity, and the way it's written in all regards, even the public sector equality duty, doesn't determine outcome. It actually only says you've got to think about these issues in making decisions. So in practice, would you accept that your perception is very much influenced by the way it's been applied as opposed to the way it's actually written?
I think that's undoubtedly true, but I guess I would say it's very hard to separate out the law as a kind of an intellectual piece of legislation, a manuscript, if you like, and the law as it is put into practice. And the overwhelming majority of people will experience the law as a practical thing that impinges upon their rights. I mean, I guess to use a silly example, when I'm driving my car, I follow the practice of the rules of the road. I don't pull my highway code out at every junction and kind of follow which letter and number and read which bit of it I'm supposed to be following. There's a practice that comes from the law, and it is the practice that most people experience in their daily lives rather than the
right.
actual
I think
written
we can explore
manuscript.
that further. But the other question I wanted to ask is you reference the idea that you want total equality, a sort of one size fits all, no differentiation. Do you accept that actually in practice your one size fits all approach would actually prevent quite positive things like single sex spaces and services, which under a one size fits all principle would be unlawful?
Well, that's a very interesting example that you've chosen, because obviously we see that the way the Equality Act has been interpreted most recently, it's actually been used to do away with single-sex services and changing rooms, toilet facilities, prisons, etc. Erroneously, I agree, and I'm very grateful to the Supreme Court recently for clarifying that aspect of the law. But until that Supreme Court judgment, in many cases it was the Equality Act, and particularly the preemptive duty that many people seem to understand the Equality Act as implying, that meant that men who think they are women were permitted to use women's single-sex facilities. So I'm a strong believer in the importance of single-sex facilities, but thank goodness we don't rely upon the Equality Act to bring those into provision. I think it's also wrong to think that we didn't have single-sex provision in society prior to 2010. Clearly we did. I lived I'm 50. I lived 4 decades prior to the Equality. I can't do the maths right now, but 35 years prior to the Equality Act coming into existence. And certainly when I was at school, we had single-sex changing rooms. I had single-sex hospital wards, etc. So the idea that we need the Equality Act to give us the right to single-sex
Can I come back on that?
I think is just not true.
The Equality Act didn't create new law in this regard. It actually consolidated about 116 pieces of legislation. So what we're talking about with regard to single-sex spaces was actually the law since 1975. So the idea that the Equality Act suddenly has created something new or something is erroneous. And I think the second point is that in practice, if you're saying you want equality under the law, then you need a piece of legislation. If you want... and that piece of legislation is, if you're saying you want a piece of legislation that only allows total equality to all groups, then intellectually single-sex spaces would go, because it's inconsistent unless you have those exceptions within the Equality Act. So in practice, the big bogeyman that's being created about the Equality Act is a lot more about guidance and training of the people who apply it, but it's also just a recognition that the Equality Act isn't just about the general principles, it's also about the exceptions to make equality law work, and the exceptions are just as important in my view as the general principles. And a lot of people decide that they don't like something in theory because the practice has been so bad. I think Joanna and I both agree on the practice. The way that equality law has been delivered over the last few years has been very poor. But I'm really concerned about throwing the baby out with the bathwater, basically. That essentially, if you want equality under the law, which is what you've said you need a law. You can't just say we don't need a law. There is no need for a law if you want that. And in practice, it's going to be either the Equality Act or something else. So in practice, what we can't say is we don't like this, but we don't something else, but we're not clear about what the something else looks like.
I suppose what I would ask, Audrey, is that's a valid point, but what you mentioned, better training, guidance is needed. There is, some would argue, a whole industry now of EDI, right? Multi-million, industry. So there is substantial training, I would argue. What would be different in your view that would make this kind of, better applicable in society?
Okay, the problem has been that equality law has been treated as some kind of sociological exercise rather than statutory compliance. And therefore we ended up in this industry, which is not actually equality law compliance, it's EDI, or diversity, equality, or equity and inclusion, which is not the same thing. Very often the materials are very much based on American sociological and gender studies type processes or race type processes, they very rarely correctly interpret the Equality Act. And when they do put anything in about equality law compliance, it tends to be cherry picked. So we get to see the headlines. We don't get to see some of the complexities or the methodologies by which you do it properly. So equality law decision making, for example, issues like ensuring universality and that conflicts of rights can happen and should be managed and how to do that are often not mentioned within EDI training. There is this sort of sense of we all should just be nice to each other and that will be fine. So in my strong opinion, I think the law is one thing. I think the practice, the training, the guidance, I have a lot of criticisms of.
I just want to give you an opportunity to ask Audrey a question. We will sort of revisit these points as we go along.
Yeah.
So I guess my question that kept recurring to me when you were speaking, Audrey, was particularly in relation to what you were saying about your work with people from low income backgrounds, because that's something that I think is incredibly important. But I mean, my awareness is that being of a low income or poverty, in effect, is not one of the protected characteristics of the Equality Act. And that's an area of inequality that disturbs me greatly. I'm from a working class background myself, and I grew up in Middlesbrough, and I look at people growing up in hugely disadvantaged circumstances, very high levels of unemployment. But I'm wondering, if you are, let's say, a white working class man growing up somewhere like Middlesbrough or Blackpool, Morecambe, some of these coastal towns, how exactly does the Equality Act help you? Because it seems to me that you don't come under any of the protected characteristics. And you look at things like the police and the RAF, it certainly seems to have become accepted that they can put out adverts, and the BBC, can target recruitment at people from particular racial, ethnic minorities or only women. And that seems to be quite lawful under the Equality Act for them to make those adverts. And they might actually be incredibly wealthy, privileged people, who just happen to be.
You've mentioned a couple of issues,
women.
so I'm going to have to give you quite a lengthy answer, I'm afraid. Let me start with the positive action stuff. In practice, white males can bring claims for race discrimination. So that's part of the universality. And there has been some problems with positive action, which have led to white males and females bringing successful claims for race discrimination or other types of discrimination where positive action has actually strayed well into positive discrimination, which is unlawful. So, the Turner Robson case or the Cheshire Police case and the situation with the RAF are all examples where people have or are actually in the process of bringing claims in the Employment Tribunal because they've been unlawfully discriminated against as white males under these processes. So in practice, that universality is the great strength of our Equality Act. The fact that the sort of positive discrimination you talked about is unlawful is another strength of our Equality Act, in my view. It means that essentially there is this level playing field. Now, there is scope for positive action. It allows charities, for example, to make special projects for particular disadvantaged groups. And I accept that this is within the 9 protected characteristics. So used properly and modestly, to be honest, because sometimes positive action schemes do stray into the positive discrimination, and I can see some concerns about poor application of those sections. And I don't particularly like, for example, the section with regard to the tie break test in employment, but that's a very, very specific criticism. But with regard to general positive action, which is mostly done outside of the employment sphere, there's some real merits to it. Just turning to the socioeconomic disadvantage point, I do think that the Equality Act is never very good at structural change with regard to, I think it's much more, it's much better on individual inequality. I don't have a problem with socioeconomic group being a protected characteristic. We did have within the Equality Act as drafted a similar scheme to the public sector equality duty, a socioeconomic duty in section 1, which never got brought into force by the coalition government in 2011. So in practice, the scope was there for some consideration of socioeconomic disadvantage, but it wasn't enacted because it wasn't liked by that particular government. Whether it will become enacted, it won't become another protected characteristic. To be honest, I don't have a strong view about whether it should be a protected characteristic or not. What I would say to you, though, is that poorer people are disproportionately affected by discrimination, primarily disability discrimination. We see up to 42,000 people a year, disabled people a year, managed out of work because of their disability. And it predominantly affects poorer people who've got less rights and less ability to challenge. So in practice, I do think that poorer people are benefiting from the Equality Act. I do think that there is an argument about extending socioeconomic group, but I do accept that it's going to be hard to define. I totally get your point, Joanna, about some positive action schemes favouring middle class black and minority ethnic people and similar. And I also worry that a lot of this is done on the basis of poor equality monitoring to actually assess who actually is disadvantaged. So, for example, you'll get a situation where there'll be an assumption that there are not enough people from a particular protected characteristic when nobody's even measured whether that's even true. So I can see some concerns. I certainly do get the public sector equality duty concerns myself, but I think that they're overblown. One of the things that the report does, for example, is talks about the public sector equality duty in the context of the employment tribunal. Well, claimants can't use the public sector equality duty breach as a head of claim in the employment tribunal, so it's rather erroneous. So, in practice, I think there is some discussion around it, but I think it has to be tempered in real facts rather than a perception.
I think the first part of what you were saying, Audrey, really hits the nail on the head for me about one of my big concerns with this. So when you were talking about how, for example, white working class people could use the Equality Act to also sue for race discrimination, but that actually really bothers me. I think it's very ugly, and my concern is that it really racializes society in a way that's very unhelpful. It tells people, you've been racial. If you can't apply for this job, you've been racially discriminated against. That you are like a white race. There's like a black race and a white race and a brown race, and you've been discriminated against on that racial basis. And if we just had laws against positive discrimination of all forms, and had equality under the law, then you could say, I'm going to sound really, really hippie here, but kind of one race, the human race, rather than you see yourself over there as a group of white people, you see yourself over there as a group of black people. I think there's something really horrible about that. And my concern is that the Equality Act really re-racialises society in a way that we'd actually, I think, made positive steps to move beyond. And I don't think encouraging people to kind of see themselves as members of racial groups to bring about grievance claims is a positive step forward for society.
Can I come back on that? I think that's a really important point. Sorry, can I just really come back on that? Ironically, if anything, the Equality Act defends people from decision making based on identity politics, because it's not about the race of the person concerned. It's the reason why a decision was made. So in practice, it's actually challenging the idea that you should recruit on the basis of race, or you should say, oh, my clients wouldn't like somebody who's of a particular colour or whatever. It's when essentially the law challenges and defends people from decision making based on the thing you're actually concerned about, when you're seeing people actually just identified as stereotypes. Kemi Badenoch, when she was introducing the report on the Inclusion at Work panel recommendations for diversity and inclusion practice, made the point, which is not a new one, but it's a really important one. The Equality Act generally is a shield, not a sword. It protects against identity politics. And I think that's something that people just don't get when you actually read the way that the legislation works and how it's enacted in court.
Yeah, and I think, Joanna, just to come back on your point, because I know a lot of people are sympathetic to the idea that the Equality Act re-racializes society, but to Audrey's point, there were times where society culturally was racialized, housing, discrimination. So there was specific exclusion for marginalized groups based on race. As Audrey mentions a lot, this isn't just about race, but let's stay on the topic of race. So without the Equality Act, what mechanisms would marginalized communities, so to speak, have to protect them? Are we really sort of that forward, as you mentioned and other people mentioned, that we can rely on sort of the goodwill of human beings to actually ensure equality across the board?
No, I don't think so. I think I'd be very naive if I said that was the case. But I guess this comes back to my initial point about the move from formal equality to a more substantive notion of equality. I mean, maybe I'm being very naive, maybe I'm misinterpreting or misunderstanding the law, but I think it should be possible to outlaw discrimination, which, I'm sure everybody here wants to do. Nobody wants to see discrimination. I luckily I wasn't alive at the time, but I've heard obviously stories about housing, people sticking notices in their windows when they're renting out houses, no blacks, no Irish, etc. And I think that's appalling, and there's absolutely no way I would want to see a return to anything like that whatsoever. But I don't think you just have to rely on the kind of goodwill of human nature. I think the law could play a very positive role in outlawing discrimination for all groups in society. You shouldn't have the adverts that say, only for this particular group, and you shouldn't have notices stuck in windows saying no Irish people, no black people, etc. But I think what's different is that we've moved away from anti-discrimination laws and what the Equality Act does in these kind of preemptive duties is something different to that. By putting the onus on preempting discrimination, it pushes us into this positive discrimination territory that I think takes us along the line of re-racialising society in a way that goes beyond just outlawing discrimination.
Okay, thank you for that, Audrey. Joanna, did you have another question for Audrey, Joanna?
I guess just to, well, it's not really a question, sorry, it's more of a comment question, and just interested to see what your take is on this, Audrey. It seems to me that one of the things that we've been struggling, or something I've been struggling with throughout this discussion so far, is the interaction between the law and culture. Or the law and social practice as it stands. And this relates back to your very first question to me, Audrey, because I think it was a very important question about kind of the Equality Act as legislation and the way it's put into practice. And it seems to me that the way it's put into practice is part of the culture that we live in. So one of the things that's been highlighted through the Don't Divide Us report and in criticisms that many people have made of the Equality Act is this idea that it stokes grievances between different groups and almost like a competition, and encourages people to make claims to victimhood, for example. To go back to that comment I was making about how I don't like the idea that white people should be able to sue for racial discrimination. I guess one of the things I don't like about it is not just the re-racialising aspect, but also the kind of victimhood culture that it promotes, that you have to, I'm a victim of racism too. I think there's something very horrible in making that, for white people, making that statement, you know, I'm a victim too. I think it's horrible that a law encourages that. But there's clearly an interplay between the law and the culture that we live in. So again, if you go back to the example you were using, Audrey, about the Sex Discrimination Act, which preceded the Equality Act and fed into the Equality Act, again, to go back to this idea of single-sex spaces, you know, way before 1975 and the Sex Discrimination Act, there were single-sex spaces. You know, Victorian England did not have an Equality Act, did not have a Sex Discrimination Act, yet was very, very rigidly divided along sex lines. You know, there were occupations that women were not permitted to do. There were rules and places and codes of behaviour that applied very, very strictly on the basis of sex. Now, that was nothing to do with the law. There was no Sex Discrimination Act. I mean, there were negative laws that impinged upon women, but I would argue it was much, much more to do with the culture of society at that time. It was the social interactions, the social behaviour, the culture that people had. And I guess that's what I wanted to ask you about. Just to me, it seems that the beauty, if you like, of the Equality Act for its defenders is that it can be used to justify cultural changes and social changes that they are trying to bring into existence by retort to the Equality Act. Oh, the Equality Act justifies us being able to do this. The Equality Act says, even if it is an over-interpretation of the law. So I'm just wondering what you think about that argument about the interaction between culture and law, and how the Equality Act justifies cultural changes that not everybody in society is on board with.
Okay, I think, again, I can see that this is an interesting argument, and the difficulty is I'm a defender of the Equality Act as it's written, not necessarily as it's applied. And in practice, you know, the Equality Act is actually quite a balanced one. I mean, you know, the ability to defend indirect discrimination, which is about policy making, as a proportionate response to a legitimate aim, led to, for example, Michaela's school last year being able to defend their policy of not allowing Muslim children to pray in the playground because it was there were various reasons relating to the culture of the school and the rest of it. So it is perfectly possible within our Equality Act to assert a culture, an ethos, which is in accordance with the society there is. I do think that the importation of a lot of American thinking on both issues relating to race and sex and gender has distorted the discussion around the Equality Act, but I also think it's got to do with ironically, the vacuum or the absence of sufficient equality law specialists, which has allowed activists to fill that vacuum. So public bodies relying on Stonewall or other organisations that provided incorrect interpretations of law, or even saying that they want to go beyond the law, has been a greater problem, in my view, than the legislation itself. Now, I'm certainly not an advocate of changing law to solve societal problems. In practice, changing legislation is difficult, it's complicated. I think the Equality Act, actually, by bringing together 116 pieces of legislation into one piece of legislation, has actually assisted us in terms of it makes it a lot easier to interpret. But the absence of good advice, the absence of knowledgeable and skilled people, the proliferation of activists misrepresenting the Equality Act has been the cause of the problems rather than the law itself.